California real estate exam free. Let's get started. Why is a standard policy of title insurance desirable under California real estate practices when transferring property ownership? Is it A, it protects against loss from fire? Or B, it will preserve a water right? Could it be C, it gives greater protection than the warranty of the grantor? Or lastly D, it will indemnify for loss from an encroachment? The correct answer is D. Here is why. It will indemnify for loss from an encroachment, option D, is correct because title insurance covers defects in title, including encroachments, that the grantor's warranty may not cover due to insolvency or absence. Option A is incorrect. Fire insurance covers physical damage. Option B is incorrect. Water rights require separate protection. Option C is incorrect. Title insurance protects against unknown defects, but warranty covenants provide personal recourse against grantor. Next question. Under California real estate regulations, for a real estate trust deed to legally exist, what essential elements must be present in the agreement? Is it A, a contract to repay the debt? Or B, a pledge of security coupled with a power of sale? Could it be C, a lien against the land in favor of the trustor? Or lastly D, a pledge of security and a debt repayment contract? The correct answer is B. Here is why. A pledge of security coupled with a power of sale, option B, is correct because a trust deed requires both the security interest and the non-judicial power of sale. Option A is incorrect. The promissory note contains the repayment contract. Option C is incorrect. The lien is in favor of the beneficiary, not trustor. Option D is incorrect. The debt repayment contract is the note, separate from the trust deed. Next question. In California, if a man grants a woman a subsurface easement to remove minerals from the land but does not designate the place of removal, what rights does the woman have? Is it A, must obtain the man's consent as to right of entry? Or B, has an implied easement to enter and use the surface to extract minerals? Could it be C, has no right of entry to remove the minerals? Or lastly D, easement rights are landlocked? The correct answer is B. Here is why. Has an implied easement to enter and use the surface to extract minerals, option B, is correct under Civil Code Section 801. An easement for subsurface minerals includes implied rights to use the surface reasonably necessary for extraction. Option A is incorrect. Consent is not required for implied rights. Option C is incorrect. The easement grants removal rights. Option D is incorrect. The easement is not landlocked. Next question. With respect to an impound account in California real estate financing, which statement is true? Is it A, the lender pays the same interest rate as a savings and loan? Or B, it benefits both the trustor and the beneficiary? Could it be C, the maximum amount cannot exceed 5% of annual disbursements? Or lastly D, it is required on all home loans? The correct answer is B. Here is why. It benefits both the trustor and the beneficiary. Option B is correct because the trustor has funds available for taxes/insurance and the beneficiary's security is protected. Option A is incorrect. Lenders do not pay interest on impounds in California. Option C is incorrect. California limits impounds to 1/6 of annual disbursements plus cushion. Option D is incorrect. Impounds are required only for loans with less than 20% down under certain conditions. Next question. With regard to a deed of trust and promissory note in California, which statement is true? Is it A, provisions of the promissory note prevail over the deed of trust? Or B, promissory note secures the trust deed and the property? Could it be C, provisions of the trust deed prevail over the promissory note? Or lastly D, trust deed secures the promissory note? The correct answer is D. Here is why. Trust deed secures the promissory note. Option D is correct. The promissory note is the debt instrument. The trust deed is the security device. Option A is incorrect. The note and deed are construed together. Option B is incorrect. The note is secured by the trust deed. Option C is incorrect. They are complementary documents. Next question. If a woman is leasing a property in California for a 10-year term and a man asks her to grant him an easement over the property, which statement is true? Is it A, illegal because only the lessor can grant such a use? Or B, legal for the term of the lease? Could it be C, illegal because the owner must join in the grant? Or lastly D, tenant can grant such a right for an indefinite period? The correct answer is B. Here is why. Legal for the term of the lease, option B, is correct. A tenant may grant easements and licenses that extend only for the duration of their leasehold interest. Option A is incorrect. Tenants have possessory rights. Option C is incorrect. Owner joinder is not required for lease term easements. Option D is incorrect. Tenant cannot bind the reversionary interest. That's it for today. How many did you score? Let me know in the comments. Please like and subscribe, and tell me what topic I should cover next. Bye.